Okay, sir, are you William Willoughby?
Yes, sir.
Are you able to hear me
Could I have
okay?
a breakout with my attorney?
Yes, absolutely. Mr. Seeger, are you able to hear me okay?
Your Honor. Yeah, that's fine, Your Honor.
Okay. Seeger, I'm going to reconnect Mr. Willoughby here. All right, Mr. Willoughby, are you able to hear me okay?
Yes, sir.
All right. We'll go on the record in People versus William Willoughby. This is file number 244988. The record should reflect Mr. Willoughby's present today by video from the Kalkaska County Jail. We have Mr. Seeger present by video and Agent Barrett, as well as prosecutor Mr. Ziegler. This is set for an arraignment on a probation violation bench warrant. And Mr. Seeger, prior to the hearing, you had a chance to speak with Mr. Willoughby in a breakout room. Is that correct?
I did, Your Honor, and in advance of the breakout room, Your Honor, I did talk to him at the jail, so I did have an opportunity to review a copy of the warrant, and he would waive further reading.
Okay. All right, Mr. Willoughby, I need to go through a few things with you with regard to your rights. Number one, you have the right to have a hearing as to whether or not you violated your probation as alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. If you are found guilty of violating your probation, it could subject you to the maximum possible penalty on your underlying charge, which is up to 4 years. Do you understand all those things that I've just stated to you?
Yes, sir.
Okay, Mr. Seeger, how does Mr. Willoughby want to plead here today?
Your Honor, he would ask the court to enter a not guilty plea. And then
Okay.
additionally, Your Honor, I did discuss with him his financial situation. It has not changed since his last appointment to Mr. Trevis, and so I would appoint Mr. Trevis to handle his file.
Okay, Mr. Willoughby, did you have a question?
I thought we was talking about something else. I'm sorry.
Okay. All right, so the court will enter a not guilty plea on behalf of Mr. Willoughby with regard to the alleged probation violations. It sounds like he'll be appointed counsel. The court will set this for a hearing. In terms of bond pending that hearing, Agent Barrett or Mr. Ziegler, do either of you have any input on that?
Your Honor, as far as I recall, and my notes reflect, the court had ordered 3 months of jail up front. I believe he had credit for 49 days. So by my math, he must have very recently been released from incarceration. He's immediately violating the terms of probation. The court also held an additional 6 months in abeyance. I think that this circumstance is exactly what the point of holding jail in abeyance is for. It's to punish violations of the terms of his height of probation. So I would ask the court to not give him a bond and or to just impose some or all of that jail that's held in abeyance pending the hearing and where we make a determination whether he's allowed to continue on probation.
All right, thank you. Agent Barrett, anything you wanted to add to that?
No, Your Honor, I'd agree. Again, as Mr. Ziegler stated, I think the court has a couple options here. All grand total from the prior to sentencing until he was released on the 31st, he's got a total of 77 days credit thus far. We're approximately 9 days removed from him entering the community and immediately drinking, allegedly drinking and other violations. So yes, I would recommend either the jail that was held in abeyance to be imposed or just continue with no bond until we get to the hearing.
Thank you. Mr. Seeger?
Your Honor, I would just ask the court to consider giving him a PR bond. And speaking of Mr. Willoughby, and I didn't follow his case closely previously, but to my understanding, he has always appeared in court whenever required to do so. He is entitled to a presumption of innocence. Some of the violations are technical violations for which there's a limited sanction that the court could impose, even if it wanted to impose a sentence, albeit I'm not sure what the judgment of sentence specifically says relative to holding time in abeyance. But be that as it may, Your Honor, additionally, Your Honor, he's indicating that he has prescriptions for various medications, including Vivitrol and Suboxone, which some of those things do have buprenorphine in it. So I'm not sure if that's why he may have tested positive for that particular substance, if he did test positive. In additionally, Your Honor, those Suboxone and the other drug are there to block opioid use. So he's maintaining that he's never used opioids or hasn't used them since he was prescribed Suboxone and or Vivitrol. So the likelihood of success on the merits is not necessarily high. If there was a violation relative to drinking, that appears to be a technical violation for which there's a limited sanction that the court can impose. He would just ask the court to consider giving him a PR bond with the knowledge that if he should come back and not be able to provide the prescriptions that he's representing that he has, that would probably be a problem. If he otherwise violates the conditions of his probation, that would likewise be a problem for him. He does not have any meaningful money available to him. Additionally, Your Honor, he did ask me to ask the court, and this is probably more related to his attorney, but he had asked for some kind of blood draw to be done to determine whether or not those substances are in his system, for which I really can't accomplish because I'm not his attorney. And I'm not sure how long, even assuming arguendo that they were in a system, that they would still remain there, not being a toxicologist.
All right, Mr. Willoughby, did you want to say something?
Yes, sir, I have active employment. I start later this week. I don't mean me missing court. I will be at every court date. I made a mistake. I relapsed. And I have not used Oxycontin. I have in my system 2 separate things that keep opiates out of my system, which will cause me to go into deathly withdrawals. I will be at court. I will follow my terms as are. I relapsed, Your Honor. I made a bad decision. Whether it couldn't be a PR to rehab would be great. But I wanna learn from this. I do, but I did not mean. I'm sorry.
Agent Barra, I signed the bench warrant, but the copy hasn't made it into the file yet. What are the allegations?
All 5 of them, Your Honor. You want me to read them?
Yeah, please.
Okay. Count 1 is violation of condition 2.0, not use alcohol. On or about 4/6 of 25, the defendant violated condition 2.0 by consuming alcohol. Count 2 is violation of condition 2.4, which says not to use or possess controlled substances, in that he violated that by testing positive for oxycodone. Count 3 is violation of condition 2.4, not to use or possess controlled substances, in that the defendant tested positive for buprenorphine. Count 4, which are the non-technical violations. Count 4 references violation of condition 1, not violate any criminal law or unit of government, in that the defendant used or possessed a controlled substance, namely oxycodone. And count 5, a non-technical violation of condition number 1, not violate any criminal law or unit of government, in that the defendant possessed or used a controlled substance, namely buprenorphine.
All right, thank you. Okay, so the original judgment of sentence, which called for probation, does provide the court imposed 9 months in jail. The court ordered that the first 3 months of that be served up front, and 6 months be held to be served at the discretion of the court. So outside of any penalties for violating probation, if Mr. Willoughby is found guilty, the court has 6 months of jail time that it can impose at any point at the discretion of the court. And I think it's appropriate, given the alleged violations here, particularly the use of alcohol and the use of oxycodone. Arguably, the buprenorphine, could be a result of Suboxone. But I think there's enough here for the court to have concerns, particularly given the short amount of time that Mr. Willoughby was out after being released. And I agree with Mr. Ziegler, and I told Mr. Willoughby this at the time of sentencing, that the court was holding that time in abeyance, and that it wouldn't have any reservations about imposing that if Mr. Willoughby wasn't conforming. So the court is going to order that he serve the remainder of the 6 months. It does have credit for time served, as indicated by Agent Barra. The court will order this set for a hearing on the probation violations, and will provide notice of the date and time of that hearing to Mr. Trevis. and to Mr. Willoughby in the Kalkaska County Jail. Now this need you to prepare it. And the court will provide that paperwork to the jail, but the court is going to require Mr. Willoughby, based on his behavior since being released on probation, to serve the remainder of the sentence that was imposed. Yes, Mr. Willoughby.
Would you be able to have a blood test done for me, please?
That's something you can talk to Mr. Travis, your attorney, about.
Alright.
Okay.
Cause I never took a blood test or anything, Your Honor.
Okay. All right, thank you. That's all for today. All parties are free to disconnect at this time.
Thank you.
Take care.
Thank you.
Hi there. Can you tell me your name, please?
Yeah, it's Shane Michael Brigham.
Mr. Brigham. Okay.
Oh, here, right here. Sorry.
Ma'am, can you unmute for me, please? Can you tell me your name? Can you say that again?
Kelsey Beckwith.
Okay. All right. Ms. Beckwith, I'm just going to put you back on hold for just a minute. All right, so we'll go on the record in Abigail McNitt versus Shane Brigham. This is file number 2414661. This was set for hearing at 2:30. It's now 2:36. We have Mr. Brigham connected, but I don't see Ms. McNitt connected. Have you had any contact with her recently, Mr. Brigham?
Yeah, a few days ago. We still talk like a decent amount. We're pretty good friends.
Do you guys want to go forward with the divorce?
Yeah.
Okay, well, the last time we had a hearing was back in March, and Ms. McNitt was present for that hearing.
Yeah, and I was not.
Yep.
Yeah,
So I need one of you, one of the two of you needs to get, there's a form called a judgment of divorce, and that's the final form that the court has to sign to finalize the divorce.
Okay.
And I told her this last time, one of you needs to get a hold of that form, fill it out, and bring that to the clerk's office here in Kalkaska, because we can't finalize your divorce till I have that form.
Okay. I know she picked up a form. Gosh, it would have been a few weeks back that I went over to her place and just looked over everything. And she said she was dropping off a form. So that could have been the form. I don't know if she made it down there or not.
Okay.
But I'm pretty sure that's the form she filled out.
Okay, she did not make it down here with that yet. I'll set this for one more hearing next month.
Okay.
So make sure that either you do that or she does that.
Yeah.
And then we'll finalize things at that time, okay?
Alrighty, I appreciate it.
Okay, you're free to disconnect.
All right, thank you.
Okay, Ms. Beckwith, are you able to hear me okay?
Yes.
All right, we'll go on to the record in Beckwith versus Beckwith. This is file number 2414620. This hearing was set for 2:30. It's now 2:39. We have Ms. Beckwith present by Zoom video. Mr. Beckwith is not present. This is set for a final hearing for divorce in this case today. Ms. Beckwith, did you get a copy of the judgment of divorce?
I did not, and that is because my mailing address, I'm not sure if it was mailed, I'm assuming it was, but David has made it impossible. He will not return my phone calls. All my mail still goes to his residence as I'm trying to get it all changed. And he won't answer my phone calls to get any of my mail or anything at this point.
Okay. Did you go online to get your forms to file for divorce in this case, or how did you get your forms for that?
Yes. Yes, I
Okay.
did. I have yet. So my brother had a house fire, and there's been just so many things that have prevented me from being able to turn them in. I have them signed. I have them on my person actually right now, and I know that it's a little late and that we're already here for today, but I've been working and I've just been trying to get everything handled, and I did not get a chance to get them turned in. But I'm not sure how this works going forward. We were supposed in the last court date, we were supposed to sit down together, David and myself, and since he's made it impossible to discuss the debt that we have accumulated together while we were married, um, I don't really know what else to do. He's not returning my calls, and there's so much debt from both of us that I don't feel comfortable with just taking on all by myself to deal with. But so I'm not sure how to go about it now.
Okay. What kind of debt do you have? Is it like credit card debt,
So
mortgage, car loans?
There's an IRS, there's a bill, we owe the IRS together like $2,300 for something to do with I have the paper, something to do with his taxes or something with his past job with Rent-A-Kill. And both of our names are on that. They've garnished my wages for the last 2 years for his child support. Things like that we were supposed to sit down and discuss. But like I said, I can't, he refuses my calls.
Okay. How about like credit card debt, car loans? Do you have any of that kind of marital debt as well?
No, we did get a car together. It's a Kia Sportage, and his name is on it. Mine is a co-signer, which that is a debt, for both of us. I had a deer and it got totaled, so we do owe that together. And I also have where I paid, they garnished my checks for, a car from Car City that I took care of that completely. But I mean, he's gotten everything, my dog, washer, dryer, everything like that. But there's only there's maybe like maybe four that we have together that both of our names are on. A car loan is one of them with the Kia, and we did go on it's paid off now, but it's a Ford Fusion from Car City that they garnished all of my wages for. And he's just not being very cooperative. So I have documentation of anything that we're both on together that I wanted to discuss with him, but
Okay. All right. So in order for me to apportion that debt and if you're asking me to assign some of that or all of that debt to him, then we're going to have a hearing here in court.
okay.
So what I would, and I can set that for a hearing, I would need you to bring in whatever documentation you have of any of the debts that you're asking me to divide between the two of you.
Okay.
And then I would have to have a hearing. Obviously, Mr. Beckwith would have an opportunity to appear at that hearing and, give his own
Defend
input
himself.
and evidence. Right. So I think that probably is the best way to go forward since you're indicating that he's not cooperating with you and he has not appeared here today. So I'm going to set this for for a 1 hour hearing. You'll be provided with the notice of the date and time of that hearing. However, we do need to have an address that I can send that to you from
Okay.
the court.
Can I give that to you now? Am I able to give that to you now or no?
I'd like you to call the clerk's office and provide that rather than providing it on the record here.
Okay.
So if you can do that right after you hang up with this call, just call the clerk's office here in Kalkaska and give them your correct mailing address. And I'll provide you with notice of the date and time of that hearing. You'll come to court. And like I said, please bring any documentation that you have, because that's what I need to be able to make that decision, okay?
Okay, perfect. I will do that.
All right, do you have any other questions?
I don't believe so.
Okay. Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
Okay, let's see. See, Mr. Koch, you're appearing on behalf of the Defendant's Road Commission, is that correct?
Yes, Your Honor.
And sir, under Susan Tuttle, can you tell me your name, please?
I'm Robert Tuttle. Miss Susan Tuttle is right here, Your Honor.
Yeah, we're using my computer today.
Okay, are you, Robert, are you counsel for the
I'm
Tuttle
George.
plaintiffs here?
Yes, sir.
Okay. So we'll go on the record. This is George and Susan Tuttle versus Kalkaska County Road Commission, case number 2514686. I'll just ask both counsel to put their appearances on the record.
Robert Tuttle for the plaintiffs, George Tuttle and Susan Tuttle.
Jonathan Koch for the Kalkaska County Road Commission.
All right, this is set for a hearing today. It looks like we have a motion for summary disposition set for May 6th. And that's been filed by Mr. Koch. So we do have a hearing coming up. This was going to be set for a scheduling conference today. I don't know, counsel, what your thoughts are, but it seems to me that maybe we should have that hearing that's already set for May. And depending on the outcome of that, proceed with further scheduling. Mr. Tuttle, what's your view on that?
We're happy to have it scheduled. I'll certainly be answering the motion for summary disposition ahead of May 6th. We have two other motions scheduled for that day as well, Your Honor.
Okay. Mr. Koch, do you have any objection to holding off on scheduling until we have the hearing on those motions that are currently set?
No, Your Honor.
Okay, so I'm just going to continue the scheduling hearing to the May date that we have set for those motion hearings. And then we'll proceed further with at that time. Mr. Tuttle, anything else I can address for your side while we're on the record here today?
No, Dan, no.
Mr. Koch?
No, not at this time, Your Honor.
All right, the only other thing I would say, Mr. Tuttle, I mean, I don't know if you're representing family here or what, but I do consider Zoom hearings to be, you know, court proceedings in a virtual courtroom.
Yes.
I'm sure you wouldn't appear in court, you know, dressed as you are today. So if you're appearing as an attorney, I would just ask that you dress as you would for any type of court hearing, okay?
Understood. I got a little
All right,
problem.
thank you.
I can't get a dress shirt on, Your Honor. I got a cyst on my neck and I can't get a dress shirt on. But I understand.
Understood. Just making sure we're all on the same page that I do consider this to be an official court proceeding, just as if we were in an actual courtroom. So that's all I have for today. All parties are free to disconnect at this time. Thank you.
Good afternoon.
Just making the point across. It looks like I didn't grab that rope sign. Not their troubles.
Yeah, they're not. Nobody's appearing, so I'm just gonna note that for the record. Okay, gonna go on the record in Shepherd versus Joslin. That's case number 2414438. That was set for 1:30. Received information that that case had settled. Regardless, neither party appeared for that hearing. So the court will set this for status conference next month. Also, file number 2414607, Rote versus Rote. That's set for 245. It's now 252. Neither side has appeared on that file. Did you say we don't have the file?
No, I'm sorry, I forgot. I did not grab it apparently.
I believe that's a case that the court indicated it would dismiss if the parties didn't appear previously.
I believe so.
Yeah.
I think they,
They were supposed to file a notice of dismissal.
right, I think it looks like they sent a letter, but not an actual notice.
Okay.
So
All right, so as to Rote versus Rote, the court's gonna dismiss that case. And will not schedule any further proceedings. That takes us to our next hearing, which will be at 3:15. We'll be in recess until that time. All right, we've got both counsel connected, so we'll go on the record. This is Dan Woods Properties versus Dobson, file number 2013517. And if I could just have counsel put your appearances on, please.
Good afternoon, Your Honor. Sean O'Mara for plaintiffs.
Yes, Lance Zorhoff on behalf of the defendants, counter plaintiffs.
Okay, thank you. We're on the record here today for oral argument on some cross motions for summary disposition. Since our last date in March, I did have an opportunity to fully review all the briefs, responses, replies that were provided by the parties, as well as all the exhibits that were attached. So I guess maybe we'll start with Mr. O'Mara. If you want to begin with oral argument on your portion of the motion, and then Mr. Zerhoff, I'll give you an opportunity, and we can go back and forth a little bit if we need to.
Your Honor, I'll keep it brief. I was going to say, if the court has any questions, fairly simple and straightforward from my perspective. The elk, there's no dispute that the defendant took my client's elk. That's admitted to. It's admitted to in his answer. It's admitted in deposition. There's no dispute that they entered his property to do so. So, I mean, he admitted it to the police. I think it's fairly clear, we don't have to throw common sense out the window that the liability for conversion, I'm not saying damages yet, just the liability is there. It's been there since this event happened. So I know that there was a, kind of this economic loss doctrine thrown out there, but that's inapplicable to the fact scenarios here. I guess really, if the court has any questions, I would like to maybe clarify any issues that you may have. Beyond that, we really kind of rely on the exhibits and the facts presented.
Well, I mean, I guess one of my questions, because it was raised, I think, in Mr. Zerhoff's pleadings, is, we have this written agreement involving the sale of these 56 animals. I mean, what effect does that have on his client's ability I mean, it doesn't seem, there doesn't seem to be any question that your client never fully paid the price outlined in that writing for the animals that were purchased. So isn't there some basis for Mr. Zerhoff's client to recover those animals if it appears that your client isn't gonna finish paying for them? Because, I mean, I think Mr. Zerhoff's argument is that the title never transferred to your client, so they aren't his animals at that point. So how can Mr. Zerhoff's client be liable for converting animals that were still his?
But that's a good point. In terms of how the state would view who owns these animals, it's regulated by the state. So that those tags were transferred and they were on my client's property. So as far as the state is concerned, they're a part of that herd. And that's transfer of title. This isn't like some sort of, that there's an underlying mortgage or anything on where they can come in and, have a foreclose. That's not how this works. The defendant purported to be a broker, right, when he was interacting with back in 2019, and he brokered the sale and the transfer of these elk to my client. They become the elk became his property once they were tagged and became secured on his property, and they were recorded with the state. All the transfer tags are there. So, I mean, in terms of the property, the minute that happens, as far as the state's concerned and the regulating bodies that regulate, the elk industry, it's considered his property. He may have a breach of contract claim, but he doesn't have the right to go repossess or that he has some sort of self-help repossession to this. That's just not how this works. And it would be counter to the essentially the regulations that the state has for elk and elk herds and the accreditation and all that.
All right, well, and I do want to ask Mr. Zuroff about the self-help part, because I do agree that that is an interesting point to me as I read through this. But regardless of what the state thinks, I mean, how does what the state considers a transfer of ownership relate to a private contract for the sale of animals between the parties? I mean, if I buy a vehicle and I have a loan, the bank owns that vehicle. I don't own it, but it's registered in my name. You know, I'm liable for what I do in that vehicle, but it's not my vehicle. And if I don't pay for it, then the bank's going to come and repossess it. So how does whether or not the state, because of transfer tags or whatever else, considers your client, Mr. O'Mara, to be responsible for those animals and liable in terms of the tags and so forth, how does that equate to a transfer of ownership under the contract where there's money that's required to be paid? I mean, you know, if he just doesn't pay the money under the contract, is just because the state considers those animals to be his, is that the end all be all of it? That, I guess, I don't get the argument that because the state considers them to have been transferred and the ownership to have been transferred, how does that mean that the terms of the contract have been satisfied and he actually has title to those animals?
I guess I think you're maybe going to like that. This would be a almost said like an automatic, perfected, secured transaction situation. It's just not. Elk and cattle wouldn't qualify as that.
I know that. I mean, I'm using that as an analogy. I understand it's not direct applicable, but my point is that how does what the state consider to be ownership, how is that dispositive of ownership for purposes of the contract between these two private individuals?
Well, I think you would have contractual rights the defendant would have. I mean, he would have contractual, but his ownership ceased to exist when he essentially tendered the elk to my client's property. And then we would have, so he would have a possible breach of contract, and we will have defenses to that. That was the first part of the kind of my intro paragraphs about, you know, that these weren't accredited and all that. And my client's herd was accredited. And then, you know, these turned out not to be accredited, and defendant had actually sued the vet. So there are a lot of moving parts, but when you break it down, I think we're getting confused. When you break it down to these were transferred and sold, right? And they became my client's property, and there was a contractual dispute. There's no question that the ownership, in terms of how the state regulates the elk and the elk herd, would be his property. Now, whether defendant has some contractual, you know, claims that he could bring, that's independent of the fact that the conversion happened and the trespass happened while my client was in Alaska. So these can, you know, I think we're talking, we're trying to compare elk to an automatic secured transaction type situation. That's just wouldn't be applicable here. So I would stand on the fact that he may have some, I suppose, claims for, you know, money damages, but he wouldn't have the right to go repossess the actual elk. So those elk are now his responsibility, and my client would have to do the testing and the TB testing and has to feed them. It wouldn't make it, this wasn't a bailment scenario where my client is just raising these elk. That's not what this was. You know, he had purchased those elk. There is a bit of, you know, in terms of the condition of the elk and what he was promised, that our contention is that defendant actually, he lied in certain ways in terms of the health of the elk and that they were accredited. I'm sure, defendant's counsel is going to dispute that, but that is the impetus of the original dispute between the parties. And so, again, my client purchased these elk for his own herd, right? He wasn't, and he would be responsible for the testing, the accreditation to ensure the survival of the animals moving forward. I think it's kind of, it's asinine to think that defendant would still be the owner of these elk at this time, given the regulatory bodies and how the state governs. It's clear and evident that the elk were my client's property at the time that defendant, came back, and I suppose he's claiming repossession. His remedy would have been to sue for breach of contract, not to come to the property when my client was in Alaska and take all of the animals off his farm. So again, and we can get into the fact that there was more elk taken than were, moving forward, but the liability is there in terms of him coming, taking the property, and then leaving, right? With my client not being there and with no permission to do so. He's claimed multiple times that the provision, there was no permission given. There was a purchase agreement where defendant was going to purchase the full farm, but that never came to fruition. He never tendered any money. He never gave a deposit down. He was going to purchase the farm for $275,000, the full farm, but he didn't purchase the farm. He instead waited for my client to be gone in Alaska and took all the animals, and then didn't purchase the farm. I mean, that's another contract that was, at least entered, mildly entered into. There was no signature by defendant, but I mean, that's also why would you do that? Why would you or why wouldn't you sign the agreement or tender the money and then go take the animals?
Okay.
Then you would have.
So if
right.
Well, I want to go back to this idea that these animals at the time they were delivered to your client in Decker, that they became his animals and he had ownership of them at that time. The writing indicates that all elk and their offspring will remain property of Double D Whitetails until paid in full. So if they became, Mr. O'Mara, your client got ownership of them at the time that they were delivered, even though he hadn't paid in full, then what's the point of that language in that contract?
I think it's useless language, to be honest. I think it was, from my, at least my client's perspective, that contract was written up. It's kind of odd. It was during the pendency of him suing the vet, and so my client was essentially trying to obtain the accreditation paperwork from defendant. And then he said, hey, could you essentially sign this? It's basically in my mind, it would make the whole deal illusory, so to speak. Like, I don't understand why that would even, I don't think it has much effect whatsoever.
Well, I mean, from my standpoint as the court, and under the rules of contract interpretation, I mean, I have to give effect to clear and plain and unambiguous language in a contract. And our argument by attorneys later that your client didn't really want to do that, or it didn't make any difference, or he was doing it for some other reason, I'm not sure that I can consider that. I mean, I have to look at the plain language. It's right in front of me. And what it says is they'll remain the property of Double D Whitetails. So, I mean, you're saying that I should just ignore that plain language because of these other factors and not give effect to that language in that agreement. I mean, that's your argument?
Well, to a certain degree. I mean, I think this was
How can it be some of the way and not all the way? Either I apply
Well,
the
no, I mean,
language or
I
don't.
understand.
I just want to know if I just want to know if your argument to me is that I should ignore that language in that contract because of the reasons that you've stated, that it shouldn't matter.
I just don't know that it does matter, I guess, is my point. The state regulates the transfer and ownership of elk, right? And
okay, so the state's ownership, the state's regulation supersedes this language. Is that what you're saying then?
I would, to a degree, absolutely say yes. Because if you looked at
again, it can't be to a degree. It can't be a little bit. It either supersedes.
Well, I would say
doesn't.
yes. I mean, it's the same thing as like, in terms of transfer of title of a vehicle, okay. I suppose, right? Like that. So just because we write up.
What authority do you have to provide me that says that a state regulation supersedes negotiated contract language between parties?
I mean, I guess we could equate it to, like you said, the transfer of a car title. I mean, wouldn't that be just because I write on a piece of paper that if you transfer it and it's registered with the state to somebody else, then that would be the legal owner.
Okay. All right. I'm sorry, I interrupted you to go back to that point. Was there any other argument that you had?
Well, I mean, I in terms of the, do you have any questions about the seizure of the elk or the fact that it's been admitted or the fact that they entered the property or anything like that?
No, not at this point. I may once I hear what Mr. Zerhoff's position is on that.
Okay. I mean,
okay, thank you. Mr. Zerhoff.
As far as it goes related to the entry on the property and the repossession of the elk, that was all consented to. Now that's a dispute, but the parties have been talking throughout that time. It's part of the affidavit that we submitted in support that they had talked about, yes, some of those elk coming back. They also was part of the negotiation of the purchase agreement. It wasn't like he was going in the dead of the night or waiting till he was gone to go repossess them. That's a dispute of fact here. So I just want to make that clear. That alone is disputed between the parties. And that would have to be actually litigated, but we don't actually have to get there because the contract itself is very clear. The contract says what it says, and that's what the parties agreed to. There are reporting obligations that the parties have related to elk. Whether or not those reporting obligations to the state don't change legal title to the animals, and the parties can agree as to who owns what by private contract. That's exactly what this is. This is a contract case, and it's contract damages. And in going through the other side's motion, they acknowledge as much on page 7 of their brief where they say he, referring to my client, would owe plaintiff the value of the livestock seized minus the debt claim owed. In other words, contract damages. He's entitled to a reduction in his debt underneath the contract for the value of any recovered animals. Those recovered animals, albeit, are owned by my client underneath the party's contract. It's not disputed that $116,600 was left unpaid underneath the party's agreement. Asked for evidence over and over and over again from the other side. Substantiate anything additional above $35,000. They did not do it. They could not do it. And so there is an undisputed amount left unpaid underneath the party's elk contract for that amount. If they have arguments that they want to make that there's a reduction for the value of the elk or the animals recovered, they can do that. That's something that the court would have to determine at a later date. But as far as the amount left unpaid underneath the agreement, we think that can be actually settled by the court as to what is that amount, and then work off that amount if there needs to be a trial on that issue. The tort claims are clearly barred by the economic loss doctrine. The case cited by the other side is Luecki versus Ann Arbor Sealing. It's not even an economic loss doctrine case. It's a personal injury case. The aggrieved party wasn't even a party to the contract. It doesn't even apply here. They are applying the standard that the Supreme Court has set for economic loss, but in no way do the facts support of Luecki support an application or non-application of economic loss here. Hunch free, which is the case that we cited for the court, clearly is analogous. It involves the same type of provision where the seller maintains ownership of the good that's being sold until it's paid for in full. And the court there said, even if you're addressing a situation that goes beyond, what the buyer or seller, I guess, for a recovery would do after an amount is left unpaid, the Hunch-Free court said that's still a contract issue. That doesn't turn it into a tort issue. It's still a contract issue. And that's because economic loss involves claims involving purely economic loss. That's what we have here. We have a contract that applies. The contract damages or contract remedy would more than adequately compensate whoever is claiming they lost here, which would be if opposing counsel's client is entitled to anything, it's a reduction off that $116,600 that he owes underneath the agreement. And we agree with that. If there's going to be a hearing on something, that's what we should have a hearing on. How much of a reduction off that $116,600 would his client be entitled to? And, based on the condition that the elk came back in, that's something that we'd have to have actual discovery and witnesses and hear from other folks. It's a factual issue. I'd point the court to another economic loss doctrine case, Morris versus Bales et al. It's a 2017 Michigan Court of Appeals decision. The citation is 2017 WL 5759787. It is pretty analogous to the situation here. There was a shareholder agreement. The shareholder agreement defined the relationship in between the shareholders and their use of corporate funds. The operating agreement defined that relationship, and the court there said, the one shareholder accused the other of misappropriating company funds. They said the operating agreement covers that, and it's a contract issue, not a tort issue. So I'd say Morris and Hutch Free, which both apply the separate and distinct legal duty, analysis. They both apply it with similar type cases and similar facts. Both applied it and said economic loss prevents tort. It's a contract claim, and that's what we have here. The reason why they alleged all tort claims is because from the beginning they misrepresented that there was ever a contract, and that didn't come out until well into this litigation when I took his dep, and he had to admit, oh yeah, there is a contract, because we actually kept the original signed copy of the agreement and put it in front of him, and then he had to admit, yep, I did sign it. And he had no explanation for why he misrepresented that there was no contract, never signed one, and then accused my client of actually, doctoring the agreement in an affidavit that was submitted to the court. So the tort claims also fail because there's the loss. My client still owns the animals that were recovered. The only ones that do not fall into that category are the 4 white-tailed deer. Now the parties had agreed that he would take those back to his preserve. The rest were all, and it's clearly laid out in the affidavits, were all taken from the pen that was designated as the pen housing my clients, or the animals or elk that they sold to Mr. Romero's client. And they kept them all in that same pen. They were all taken from that pen. And if you look at the list, a handwritten list of the animals that were removed from the Kalkaska farm, there is a total of 35 total elk, which is less than the 56 that were sold. And, there's presumably offspring from the elk that were sold, the 56. There's 35 that are listed here that were taken back, and then the $4. That's less than the full amount. So we are talking about what is the amount of any kind of offset that they've been entitled to off the total amount that's owed underneath the parties' clear agreement. Those are animals that they lost, and the parties had agreed that he would repossess them in order to take against the contract. And regardless, I mean, what his remedy is a reduction of his overall amount owed underneath the agreement. And then the one other thing I did want to point out is this whole idea that, there was some kind of fraudulent scheme related to the purchase agreement. My guy was still pursuing the purchase agreement when the other side unilaterally cut it off, and he was frustrated because the deal wasn't moving fast enough. His own broker is the one that sent us an affidavit. I just sent him a subpoena. The affidavit came back, and the affidavit read, yep, I was told to cut off all dealings with him, not talk to him anymore, and he kept calling. They called off the purchase agreement, and they did so knowing that they had already let animals go to the preserve and knowing that they can't come back. They go to a hunting preserve, those animals cannot come back. They have to be shot once they're on the hunting preserve. He knew that. He was in the industry. He knew that. And even though he knew that, he still said, deal off. I'll deal with it later, and then sued like a week later. And sued for conversion. It didn't even mention the contract that he had signed, which clearly applies. So I suspect what he's trying to do is trying to rely on the tort troubled and other types of punitive measures that are out there. But there is a contract. It applies. It clearly addresses the animals that were taken back, and it doesn't address. We didn't even take all of them back. It was just some of them. And I think the only thing that really needs to be addressed by this court is what's the amount of the reduction off the overall 116,600 that he's entitled to, if at all. I mean, the condition of the elk when they came back were not good. So, I mean, that's something we'd have to take evidence on. And, if there's an amount of value that we got for those, whether it's for, meat or whatever else, we'd have to take testimony on that. But the rest of it's pretty clear, and it's clearly a contract case and should be limited to contract damages.
All right, thank you. Mr. Zuroff, did you want to present any argument on your cross motion or on your motion?
Well, I would say I tried to while I was going. So if I didn't come across, the economic loss to me is really clearly does apply, and the case law that we cited absolutely is dead on point. And if you read both of the cases, both Morris and Hunch Free, I don't see how you don't apply it. I'll be honest with you. The case that was cited, Lowecki, doesn't even apply here. It's a personal injury case. I was kind of surprised to see it. So I think it's really clear there. I also think it's also clear that there is yes, we have to do an analysis as to what the reduction would be, but I don't think they can state a tort claim for the alleged loss when my client owned the animals. Particularly, we're talking conversion and all these other tort claims, which require him to be the owner of the items. He's not. Underneath the contract, he's clearly not. So regardless of what the state thinks, that's what the parties agreed to, and that's what's enforceable between the two parties.
If I may briefly respond. There was the affidavit of Dale Reinhardt clearly suggests that he took way more than just even the disputed elk. There was, in fact, there were bulls that were already there that we will ultimately be able to show. We're talking a pet that was raised by, the family was taken and ultimately shot at the game reserve as well. But in terms of economic loss, I think there's, I think you're trying to fit a, you know, a circle through a square scenario here. The economic loss, my client has a right to be secured in his personal property, right? So that's independent of any contract like that may exist. The right to be secure in your personal property is, I mean, that's common law. That right exists. So the fact that the original complaint didn't was filed based in tort, based in securing his personal property from trespass, economic loss doctrine doesn't apply to that fact. You can have a contract and then have independent rights that are also violated. So that, I mean, that's clear as day here. So you're trying to state that this contract makes, I mean, it's like if you know, I tried to do a very simple analysis here, or example, but if I'm in a contract with you, Your Honor, to, you know, sell widgets, and then I break into your house to obtain some of the widgets that I think are mine, I've committed a trespass. And then I take your TV, you know, that's also a conversion. That's just because we have a contract does not excuse those rights, right? You would have a absolute right to sue me for trespass, plus I get criminally prosecuted. But that's, so this thought that this contract eliminates the trespass claims is kind of, it's misplaced completely. And the cases cited in that is the Supreme Court's, in looking at this, I mean, a contracting party, assumption of contractual obligations does not extinguish or limit pre-existing common law or statutory tort duties. It's just that's so, because the original, and that's what we're dealing with here. He has a right to be secured in his property. He has a right, if he leaves to Alaska, to not have people come onto his property. He has a right to his personal property, which are the elk. Those are all, that's independent of any contract. So I don't understand how economic loss theory would even remotely apply to plaintiffs' allegations. I mean, to the claims brought. They don't. They're completely independent. Anyway.
All right. Okay. Thank you. Oh, so again, I had a chance to go through all the submissions of the parties. I appreciate the arguments of counsel here on the record today in clarifying some of my questions. And number one, I think it's important to note the court is reviewing this under party cited C8, but I really think this is a C10 motion. It's really a question of whether there's issues of fact here, or whether one side or the other as to the tort claims are entitled to judgment as a matter of law. And as the parties are aware, correctly cited the standard, the court has to find that there's no genuine issue of material fact outside the issue of damages, and that no reasonable jury or fact finder could find in favor of the non-moving party. So, and looking at this, number one, you know, I'll just say there's nothing I would like to do more reading through the claims here than narrow issues for trial, and to eliminate claims that aren't appropriate at this stage following the discovery that's been done. I don't think I'm going to be able to do that. What really struck me as I got into the facts here and really read through the deposition testimony that was offered, the affidavits, from a factual standpoint, this is a really big mess. And, you know, I can appreciate the difficulty that I think the attorneys have had over time here, trying to sort through all these different events that took place, the different outside litigation that was going on, you know, just the whole sequence of events from the delivery of these animals to the Decker facility, the transfer of those animals up to Kalkaska, what condition they were received in the Decker facility, whether that delivery was as the parties agreed to. We've got this writing, which, I'm sure counsel can acknowledge, in terms of a contract, is just woefully inadequate, given the nature of this transaction.
Not in this industry.
Well,
I'm serious. That's actually
and you-
detailed for this industry.
I think that's why the state kind of regulates it, so.
Yeah, so, and maybe that's it, and maybe this is how parties deal with each other, but to me, it's just a mess, because then these animals get moved, they're mixed in with other animals, nobody can really tell which ones are which anymore. Then there's this whole negotiation for the property in Kalkaska that falls through, and then one party ends up showing up and repossessing animals. It's just a big mess from a factual standpoint. And where I really come out on it is, I don't think either side has shown that there aren't issues of material fact when it comes to the tort claims. And primarily, number one, I disagree that the economic loss doctrine applies in this case. I read the cases that the parties cited. What it comes down to for me in this type of transaction is the principle that under the economic loss doctrine, you can't bring a tort claim where the duty alleged to have been breached arises from contract provisions. And I think if you accept plaintiff's version, Mr. O'Mara's version of the facts here, Mr. Zerhoff's client clearly went outside the terms of the contract. There's nothing in any of the agreements that I saw that would allow him to go and unilaterally repossess animals. Certainly wouldn't allow him to take animals that were outside of that contract. And I think there's a question of fact of what animals actually were taken, and were they only limited to the ones that were transferred originally, or did they involve other animals that were part of the herd? If offspring was taken, was it offspring from the animals that were part of the transaction, or were they part of other animals that were part of the herd? So from a conversion standpoint, I think, again, accepting things in a light most favorable to the plaintiff here as the non-moving party as it relates to Mr. Zerhoff's motion, there are questions of fact in my view. And the duty that they're alleging was breached is outside of just the contract provisions. I mean, they're alleging that, as Mr. O'Mara has argued, that his client had the right to be secure in his property and his belongings, and that was breached by the repossession and entry onto the property. I understand Mr. Zerhoff's argument that this was part of the negotiation and there was discussions, and that it may have been permissive for his client to go get those animals. But again, that to me is a question of fact. But I don't think for those reasons that the economic loss doctrine prohibits the tort claims in here, because in my view, the duties that are alleged to have been breached are duties that are outside of the very limited contract agreement. So I think there are questions back on that, but and that cuts both ways with regard to Mr. O'Mara's motion. I think that depending on what a fact finder might determine, the fact finder could very well find that there was some type of agreement or permission or other authorization for Mr. Zerhoff's client to go and repossess those animals and to enter onto that property. So I just don't find that it's so conclusive one way or the other that either party is entitled to summary disposition on the tort claims, either from a factual standpoint or, again, from an economic loss doctrine standpoint.
So could I ask a question?
Sure.
Is that related to not just the trespass claims, but the other ones? So the conversion requires ownership on the other party has to be able to establish that they own the animals.
Right.
I thought it was pretty clear that, as to who owns the animals underneath the contract, and there's nothing to undermine the contract. So to me, I don't know how you get around that, either from a cause, an element standpoint on conversion, or underneath the economic loss doctrine. Trespass is the only one that I could possibly see getting around the obligations that are addressed underneath the contract. And even that one, first of all, I think what he meant to allege was personal property trespass, not real property, because real property, the damages for that, which is set forth in our brief, is related to damages to the actual, property itself. Well, where personal property trespass is different, and that relates to ownership of the actual items that are taken. So protecting that whole right of security in his property, if you believe, the version of facts that are set forth by the other side, I could see how that might be breached, but the damages are different. And the contract clearly covers the other ones, and I would confidently say that it does, and related on the case law that I've read, but I guess my question is whether or not it applies to all. It seems like, there's two different things here. I think there's the real property trespass that was alleged, and then the other tort claims. But
yeah, I mean, I see two things on the conversion. Number one, it's far from clear to me under a summary disposition standpoint that only animals that your client has arguably had ownership of were taken. There may have been other animals that he didn't have a claim of ownership to that were taken. That could be the basis for the conversion claim. And then number two, under the contract, there's nothing that gives him the right, even if he was going to go take animals that he had ownership of, there's nothing under the contract that says that he can engage in self-help and just go there and decide for himself which animals are his and just leave with them. So I think there are two bases for those claims to go forward. And with regard to the trespass, I mean, I think that's an issue, again, of fact. What the discussions were between the parties, did he have the right to go on that property? And then what were the damages, whether the damages would relate to the animals themselves or damages that were done to the property. I think there's this issue with the fence. Was that damage? And whose fence was it? That's far from clear, again, from a summary disposition standpoint.
Yeah, that's outside the contract.
There's just a lot. There's a lot out there. Like I said, I would love for something in this case to be that clear to me under a summary disposition standpoint where I could grant one side or the other summary disposition so that we could bury some of those claims outside of the damages issue. But I just don't. The fact pattern here is so complex, and each side's version of it is so different, really from beginning to end, that I just don't see it. So again, I appreciate counsel's work on this. I appreciate your arguments here today.
Those clarifications help. Those clarifications help on the conversion and the other ones.
Okay, so that's ruling. I guess what I would, because we had kind of cross motions here, do the two of you think that you would be able to get together and agree on the form of an order? Basically, I'm just denying both sides' motions.
You wouldn't mind just sending an order, just saying denying both motions? I mean, unless you want us to put it together.
I typically do. Yeah.
Okay. That's fine.
All right. Okay.
So just denied.
All right.
But
should we get some dates moving forward?
I don't know if we have anything set. Let me see if we have a next date.
No, this looks like the last thing that was.
Okay,
set.
so we don't have any next dates set on the calendar, so that is a good idea. Mr. O'Mara, any suggestions as to how you'd like? I mean, want to take this back to your client, and I don't know if you guys want to have some.
I was hoping to get, it maybe a trial date for later maybe later this year at some point, just to get a drop dead date. This has been, I'm kind of new on the file, but I mean, this was filed in, I think, 2020.
Do we have a jury demand here, or is this going to be bench trial?
I believe trial.
It's a bench.
Bench, okay. That's good, because I think this would be really difficult for a jury to hash out.
I wouldn't even want to try.
How much time, how far ahead do you guys want me to set? I don't mind putting trial dates on the calendar, and then we can work backward from that. So first of all, I guess, how many days of trial do we think we would need? I mean, are we going to need 3, 4, 5 days here? It feels like it would be a lot of time.
I think there's quite a few witnesses ultimately that'll be hauled in. I would like some time just to get kind of that all. I mean, I was hoping to get maybe, you know, I know this sounds, but maybe like September, October, kind of a tentative date. So it would be later towards this year, just so we could start kind of gearing towards that. I don't know, Lance.
Well, why don't we do this? Because
maybe me and Lance could talk, and maybe we'll submit a stipulated scheduling order. I don't know. Maybe that would be easier.
Yeah, it's hard for me to put tentative dates in because I can't really afford to take up dates that aren't for sure going to get used in my trial calendar. So why don't we do this? I'll set this for a status conference, scheduling conference next month. In the interim, why don't you guys talk to your clients, talk to each other, you know, and then at that point, maybe you can come to me with like some realistic estimates on how many days of trial you think we're going to need, how much time you're each going to need to get your case prepped so that you're ready for trial. And then we can set some dates at that point. How about that? Any objection to that, Mr. O'Mara?
No, that's a good idea. That's why you're judge.
Mr. Zerhoff, any objection to that?
No, that works.
Okay, so I'll set this out for a scheduling conference next month, and we'll go from there. And thank you both. You're free to disconnect at this time.
Thank you.
Let me see if we have our All right, can I have Mona at this table over here, please? And I need everybody who's going to watch, you need to sit in the second row, please. Yeah. And then Geneva, where's Geneva? Right there? Okay.